Okay, good afternoon, everyone. Thank you for joining us today for the presentation on selected in the H-1B lottery. Now what? This webinar is being recorded and the recording link will be emailed to all attendees. This webinar is provided as an educational service by Alcorn Immigration Law. The information discussed is an overview only and should not be construed as legal advice or advice to take any action on. Please be sure to consult a knowledgeable professional with assistance with your particular issue. Lastly, please submit any questions you have or may have by using the Q&A function. Right, and the questions are shared publicly, so please do not share any sensitive or personal information. There is an option to submit your questions anonymously. We will try to get to as many as possible as time permits. And it is now my pleasure to introduce you to our CEO and founder, Sophie Alcorn, and our expert business team attorney, Carolyn Island. And this information will be shared. There we go.
Okay, thank you so much, Alex. And you'll start recording?
Yes, I believe the recording has already started.
Fabulous. All right. Well, hello and welcome. Thank you to everybody who's attended today. Carolyn and I are going to be talking about what to do if you or somebody you would like to employ or currently employ has been selected in the H-1B lottery. So what are the next steps? So great to have you here. We are going to leave time for your questions at the end. And please, if you think of your questions and don't want to forget them, please share them in the question and answer panel throughout the presentation. And we're happy to also answer them as they relate to our talk. So thank you so much. And it's great to have you here. And with that, we'll get started. So our story is Alcorn Immigration Law is one of the probably fastest growing immigration law firms in the country. We started 6 years ago in my kitchen and we've grown. We are rapidly scaling along with our tech immigration startup clients. So it's very exciting. Our mission is to overcome borders, expand opportunity, and connect the world. And we do that because we practice compassionate, cutting edge, and rigorous immigration law in service of the betterment of humanity. So we love using creative and novel and winning new strategies to support our clients with communication and compassion and integrity, because we know how important U.S. immigration is to you and your company. So I'm Sophie. It's great to be here with you. You can subscribe to my podcast called Immigration Law for Tech Startups, and you can catch my weekly column in TechCrunch Plus called Dear Sophie, which is an immigration advice column. I'm the founder of Alcorn, and I am so pleased to be joined today by Carolyn Island, who's a leading business immigration attorney at Alcorn Immigration Law. She has a rich and deep experience in various types of immigration practice and has really honed her skills in H-1Bs and PERMs and working with startups on all of their tech immigration needs. So welcome, Carolyn.
Hi guys, it's a pleasure being here.
Thank you so much. We have a lot to talk about today and we see your questions coming in, so thank you so much. Here's an overview of our team as well. I think that one of the reasons we've been so successful and able to grow so quickly is because of the wonderful people who are collaborating here to support our clients. Everybody cares a lot about immigration at Alcorn, and it's either it's mostly through some personal connection. Like my mom was an immigrant from Germany, and several of our team members are immigrants themselves or married to immigrants or children of immigrants. So it's really personal for all of us, which goes into our approach of seeing our clients as individuals, not cookie cutter or volume based. We are here to give all of our individual clients the attention they deserve. We are part of a vast Silicon Valley venture capital education startup ecosystem, and we are happy to leverage these connections for our clients, introductions to VCs. I'm a mentor at 500 startups. We're connected to a lot of folks in Y Combinator and represent a lot of Y Combinator companies. You know, the TechCrunch, I'm always interested in interviewing successful immigrant founders who have made it on my podcast and writing about that in TechCrunch. So we're excited to leverage our network and connections to support our clients' success in the startup ecosystem. And Carolyn, let's get started with an overview of immigration just to place the H-1B lottery into context. So can you describe the various paths to the United States, just for somebody who's maybe completely new to this?
Sure. So U.S. immigration law kind of has two streams that you can go down. And one of the streams is either a family member petitions for you, either through marriage, your parents, your brother or sister. It's called having a qualifying relative, and they're able to petition for you. That's one way to go about it. But for what we'll be discussing and the options that we usually work with are through employment based. So a company here in the US, or there's a company abroad that's looking to bring someone to the corporate entity to the US, is looking to hire an employee or an existing employee and sponsor them. And you need to have a visa status here that has an employment authorization attached to it. And usually it is either an L1, an H-1B. There's an alphabet soup of different visa types, but for y'all in this seminar today, you're been selected for the H-1B, which is a dual intent non-immigrant visa. You are allowed to work on it and stay in the US for initially 6 years. You are also allowed to file for a green card or go through a employment-based green card application process during that time. Yeah. There's different avenues to go about that as well. Mm-hmm. But eventually, if your green card is approved, after 5 years after your green card is approved, you're able to apply for US citizenship if you so choose to.
Yeah, awesome. And probably for most purposes today, like people are here because they were selected in the H-1B lottery, so they're probably not going to need to worry about getting a green card without getting an H-1B first.
Correct. This is typically the way we like to phrase it is we want to focus on one thing at a time, especially if you're in a student status and you're just getting hired to a company. There's a lot of changes going on and a lot of things happening for you. So for immigration purposes, we want to focus on one process at a time. So we'll tackle the H-1B, get that approved, get you situated, and then later on, we can focus on the perm, because they're similar, but they do have different legal requirements, and we don't want to overwhelm people by asking for one thing and then it having to go towards, does it go towards your perm or your H-1B? So we try to keep it simple and streamlined.
Cool. Thank you so much, Carolyn. And can you talk a little bit about the typical student immigration journey? I know we already have a question about consular processing versus change of status, and we have a whole specific slide on that where we'll be covering it. But can you just talk about maybe some of the differences, because folks who are attending, maybe the beneficiaries are on their first year of OPT, or maybe they haven't graduated college yet, or maybe it's their very last year of STEM OPT. So how does that look for different candidates?
So for people who are in the US going to school, there is an option for you to work, because part of what the government wants is you to get experience and use that education, use that degree. And so for non-STEM degree fields, and these are usually your humanities, your pretty much anything outside of the STEM list, you get a 1-year work authorization after you graduate. And this applies to each education level. So say you get your bachelor's degree, but then you want to go for your master's. after that, then you would still be able to get that another year of STEM OPT after you graduate. For those who are in a STEM field, the US government recognizes that we are in desperate need of people in these degree fields to support and work, and they have such value here in the US. So they get 2 years of qualified work experience after their first year of OPT. So they get totals 3 years after they graduate. And it is great because you have more opportunities to, if you're working with an employer, to get selected in the lottery, which luckily you have been if you're interested in this webinar. And if you haven't, there are options that we can work and plan out and strategize with you a lot easier. Once you are selected from your STEM OPT and you're moving into H-1B status, the question is deciding on how much time do you have left on your STEM OPT, and what is the best option for you in regards to travel, in regards to looking at your work history, and if you need to be outside the US and to change your status to H-1B really quickly, and we'll touch base on this more, or if it's best if you kind of stay right out your STEM OPT, finish it up for the additional 2 years, and then transfer into your H-1B at a later date.
But here's a question we can answer now, and we do prefer if you put your questions in the question and answer panel, and I believe there is a way to ask questions anonymously in the Q&A panel, but I think we can cover this one right now. Should I apply for my OPT extension in case my H-1B doesn't get approved? So this is somebody who's approaching the end of their first year of OPT, they're eligible for STEM OPT. We don't know if they're going to do consular processing or a change of status, but in general, if somebody's STEM eligible, would you recommend that they apply?
Yes, absolutely.
I agree.
Because that way, if, again, we don't really see a lot of denials in our cases because we do a lot of prep and make sure that we have a highly approvable case when we file it. But USCIS makes bad decisions sometimes, and the last thing we would want to do is put you in a position where you're scrambling and you're under that stress of, oh snap, now I need to go file my STEM extension right now if you are still in your current status, or now I'm out of status, now I need to leave. So we definitely try to avoid that as much as possible, and the cautious approach is to file your STEM extension. And if it is a situation where you want to stay in that and not go directly into your H-1B, we can touch base and give a further explanation, but that is completely possible for you at this point.
Yeah, and one of the values that our attorneys share in how we practice law and support our clients is we understand how important this is to most candidates' futures and most companies' ability to succeed, especially in like Silicon Valley, where it's so high stakes and early stage team members are critical to the growth of the company. You know, for lots of reasons, this really matters a lot to a lot of people. So we take the conservative approach, and if there are multiple compatible things somebody can qualify for, and it would give them more immigration security and more peace of mind, we generally advise our clients to go for it if you have that chance. Okay, so let's go a little bit more into the H-1B basics. H-1Bs are for a specialty occupation. That's a legal term of art, but you can think of it as a professional job. So the government is looking to see at least a bachelor's degree, or if somebody didn't get a bachelor's or dropped out, that you have equivalent work experience. The company is going to have to pay a minimum wage, which here we call the prevailing wage. It depends on where the person's working, what their job level is, what their job classification is. We just got through the lottery. So just because you got through the lottery doesn't mean that you have a qualifying H-1B. And we'll put our contact information at the end if companies want to chat with us about preparing and filing the H-1B petitions. That's something we do. That's our bread and butter. But somebody could get through the lottery who is technically unqualified. So just because you got selected by April 1st doesn't necessarily mean your H-1B is going to get approved, and doesn't necessarily mean that, like the candidate might not actually qualify. Somebody who never went to college with 11 years of work experience would not qualify, but somebody with 12 years of work experience would qualify. So like, these are the technical things that we know when we assess candidates. The company might not have the ability to pay the prevailing wage. And you say, well, what's the prevailing wage? And we say, well, we can't tell you that until we know more about the candidate and the work location and the job, but that's why you hire a lawyer to figure this out. But we can say that we've successfully used the H-1B for even employee number 2 at an early stage startup with even the smallest amount of pre-seed friends and family round funding to create an MVP. So this does not require millions of dollars raised or hundreds of thousands of customers. Very early stage companies can pull it off if you meet the requirements. Carolyn, let's talk about, for folks who are at companies and their candidate just got selected, what it's like to work with us and what the next steps of the process are, okay?
Sure.
Okay.
So if you did utilize us to submit your registration, you've already received a communication from our teams letting you know that you have been selected. And we asked to confirm a couple of pieces of information, either through on the employer end or the employee end. And one of them is mainly if from the employer, if you guys want to move forward with premium processing versus regular processing. And this is an important decision because premium processing is an additional legal fee of $2,500, but there is a benefit to it in that we get a decision on cases within 15 business days after filing. So either we get an approval, a request for evidence, or in the unlikely chance, a denial.
Yeah.
And this is super important for our F1 students, especially those on cap gap and those who are in that transition period where they need to know what's going on in their case, and having that luxury of they don't have the luxury to have a long processing time for their H-1B.
I think it can also be important for very important team members that have a lot of anxiety because their work product might slow if they're super stressed about waiting. And it could also be very important for like VIP founding team members, executives, where you really want to like go the extra mile.
And it's the additional benefit of premium processing is that we get electronic receipt notices. So if people are, we get an idea of when USCIS receives a case quicker than waiting for the printed receipt notices or communications through their case status website. And then we get electronic approval notices as well. And again, it is a comfort and a peace of mind of, okay, I've been approved. Now I can actually plan for the 6 months. Now I can actually know like where I'll be working or what's going on, or do I need to do my, can I travel? Do I have that ability?
Carolyn, in past years, without premium processing, I know that in Obama, like H-1Bs would get approved by July, but under Trump, we had normal H-1Bs without premium processing getting approved in like December after the start date of October 1st passed. Do you recall any data points from last year of people who didn't use premium processing when the adjudication came through?
From what I saw personally, and even with some of my friends who, personal friends who were going through this process, they didn't get approvals till just October, November, December.
So I think the people who can skip premium processing are people at the beginning of OPT doing a change of status who aren't traveling and who don't care, or people out of the country who are in no rush to come here.
Exactly.
But probably everybody else, it's just a best practice to pay USCIS the extra $2,500 and do it.
Exactly. And there is always a chance that USCIS could suspend premium processing during
Oh,
cap
that's
season.
true. So you maybe get it
However,
while it's hot.
from what the indications and just the recent policy directives they provided, where they're looking to expand premium processing as much as possible, I think that we're pretty safe that it's not likely they'll suspend it this year, because they didn't last year.
Okay. Yeah, hopefully they won't this year. Let's talk about the second bullet point here, and it goes with a question we got from the audience. How do you decide if you're going to do a change of status or consular processing?
Main consideration is if you have travel plans between us filing your petition, which can be anywhere around mid-April to June for this first round.
So if you're in the US and you want to travel this summer, then what would you recommend?
One, communicate with your team, because we do have a little bit of flexibility of when we actually file your petition. So if your travel plans are early summer and you'll be back before we have to file in June, great. Then we can wait for you.
So like, we don't want people to travel with a pending change of status.
Correct.
Okay.
Correct.
Okay.
But if it is a situation where you know that you'll have to be outside the US after we file, then we would recommend just doing a consular process notification. The main consideration for that, though, is we want to make sure and check your status, because if you're someone who is on cap gap or someone who is in a student status that will expire either after your filing or before October 1st, you'll be stuck outside the US until your petition start date on 10/1 is available. So the decision on whether to do change of status or consular processing, your legal team is more than happy to direct you and walk you through pros and cons of it and explain what the risks are. But main thing is if you are on cap gap, or that you don't have any travel plans for the summer, change of status is a great option, because you automatically change into the H-1B on 10/1. You don't have to do anything.
And then the other interesting situation I've seen, which is very specific, unmarried person born in India or China, maybe is about to graduate and hasn't activated even their OPT yet. So they're at the beginning of their OPT. Sometimes those people decide after consultation that they want to do a change of status, that they do not want to do a change of status, even though they're eligible. They want to preserve all of their OPT. So they're going to get their H-1B by consular processing. They might not even activate it or get the visa for several years, but this way they get more work experience before, just because the green card backlogs are so long. The idea is don't activate the H-1B until the end of STEM OPT, or until your company is going to start the perm process for you, so that you're maximizing your available time in the United States.
Yeah, and that is a strategy like we do advise on, because again, we take a holistic approach when looking at your case. Because even though you're on an H-1B, if you're someone from a country that has a backlog, we're thinking ahead. So we're thinking of what is the best option for you and your employer to get you to not have to duplicate efforts as much as possible, and can give you guys extra time. So those are definitely considerations we'll go over and discuss.
Thank you, Carolyn. What are the deadlines that people need to keep in mind?
For right now, the June 30th is the major deadline for those who have been selected. That is the date that USCIS will have to receive this first round of H-1B petitions by. The filing deadline was from April 1st till June 30th. And right now, if you have been selected, our team already did the majority of document collection from the candidates earlier on this year. So we are in the process of reviewing and the questionnaires and documents that we have, preparing the LCA or the labor certification, and working to get that reviewed and filed with the Department of Labor. If there's any strategy questions, or if there's anything that comes up that we need to discuss with employers in regard, or the employees in regards to if they qualify, or if they have a degree field that we think that could be challenging or problematic, this is the time that we're working with the employers' employees on this. Cool. The other major thing to be aware of is if you're in cap gap.
Yeah.
So cap
I know
gap,
some people's like STEM OPT work permit might expire May 15th. So what do they need to do if their final year of OPT ends before, OPT or STEM OPT ends before June 30th?
So our team has already reached out and communicated for the individuals that we've flagged that are in this type of situation where you have cap gap, or you have a OPT expiring before the June 30th deadline. So we can work to get your application filed ahead of that, because in this situation, we would have to get your H-1B petition filed before your current student status expires.
Yeah, and just to clarify, it's the last date of employment on the EAD work permit. It's not the F1 grace period. So
correct.
We want to be hyper vigilant about that. For folks who have not yet retained a lawyer, what do they need to do?
One, at this point, it's
hire a lawyer.
Yeah, hire a lawyer, because we do need to take the time to do a consultation, review the case, and make sure that for you as an employer, we don't want to file an H-1B that could potentially be problematic, because part of the LCA process is that you certify to one, that you can pay the wage, two, that you aren't under any labor strikes, or you haven't had any
lockouts.
Exactly, stuff like that in recent times. So we want to make sure that we have the chance to go over with that with you guys as soon as possible. And then also right now, hiring a lawyer so we can get questionnaires out, we can get the document collections going, because it does take a significant amount of information.
Yeah, and we'll have next steps for that we'll share with everybody. And then we do, I mean, Carolyn, you've already alluded to this, but there's a lot of I always remember the expression, like, nobody wants to know how sausage is made, but there's a lot of stuff that you do, our other attorneys do, our paralegals, our legal administrative assistants, that we're all doing behind the scenes to help our clients. It takes a lot to get that package of documents together. There's forms, there's certifications, there's signatures we need, there's evidence in various things, there's attorney cover letters, there's all sorts of analysis. So there's a lot, and but we handle that for our clients. But you know, at a certain point, we won't be able to accept any more cases and get them done by the deadline. So if you're here because you did the lottery registration yourself and you need help, please reach out to us immediately if you would like.
Give us as much time as possible, because we do, our team is very efficient. Like Sophie mentioned, we have H-1Bs down to a very specific, I hate to say like a template or like but we are very good at it. We are very streamlined.
We're good at it so that we can focus on the most like personal parts and put our attention there and help you all with your decision making. But yeah, but we need to know now if you want us to help you. And then okay, so we've had our candidates selected in the lottery. We've engaged with Alcorn. Alcorn has prepared everything. We understand what our deadline is. We're filing before the deadline. Next, it's going to USCIS. So what happens?
So we kind of already touched based on the premium processing. For regular processing, again, without, it can vary. Right now, USCIS typically quotes 4 to 6 months for regular processing for an H-1B case. During cap season, that does increase significantly because right now they have about 60,000 cases heading their way. So it can process and it can extend out. If you either get an approval after filing, either premium processing or regular processing, or you could get a request for evidence. And RFEs especially for people, if this is your first time filing an H-1B, seems really, really scary. And it seems like, oh my gosh, what was wrong with my petition? What was wrong with the filing? And it's a situation where RFEs were super common during the Trump administration, kind of as a stall tactic by them because they had so many cases they were trying to process at one time. They would just send out a templated RFE, really not
boilerplate. Nobody read the thing.
Yeah. And based off of me working in different committees, they have a database where they just click the RFE and put things together. And there's not a lot of, if we get one of these boilerplate RFEs, great, because we know we can respond to them.
Yeah.
We have the expertise to respond to them. I've processed hundreds of these type of boilerplate RFEs. The bigger concern is if there is a specific issue or if they're actually asking questions about maintenance status or any specific
Which is why we want
individual
to be so
issues.
careful at the beginning.
Exactly. And that's why we take the time to review your background, make sure that there aren't any things like that that will pop up.
Yeah.
And so if we do get one of these boilerplate RFEs, we typically have 90 days to respond after. And it's a situation where we'll need significant more documents, but this kind of goes into our filing strategy where we know that there's a potential for RFEs at any time. So we give USCIS what they need and what's approvable, but we don't give them everything that we possibly could because we want to have support evidence available to answer an RFE if we do get one in the future.
Yeah.
And then
you reminded me of this company where I filed like 50 H-1Bs for the same job type, and 38 of them were immediately approved. There were 12 requests for evidence. 7 of the requests for evidence were identical, and the other 5 were all individual, but like it made no sense. They were all the same, right? So there's some variation and arbitrariness in this whole thing.
And again, I do want to say though, as scary as an RFE is, or if it may seem like because it does delay the process overall because you have to respond to it, but it is not the end of the world. It does not mean there's anything wrong with you or your case, or that your case will be denied. It just means that the government's likely trying to stall, or they are just something flagged when you submitted the petition.
And just so everybody has a little more peace of mind on this, you know, even under the Trump administration, when the RFE rate was up to like 40%, we're so thorough, like we were only getting RFEs 10% of the time, even in those times. And under Biden, the approval rating has increased and the RFE incidence has decreased. So like we're very confident when we file somebody's case.
And even with the RFEs that we've been seeing recently, it's more silly ones, or they're ones like asking you to confirm your worksite location, even though we have done that already because the government hasn't caught up to tech worksite or our mobile workforce. But again, all of these are easy.
Oh, but that's a really good thing to mention. We do get H-1Bs approved for people doing remote and hybrid work. So
absolutely,
if your company isn't requiring people to come into the office, it's still possible to get an H-1B.
Yes. Yeah. And again, this is one of the areas of specialty that we have that not all attorneys know how to address this, especially older practitioners who are very used to traditional corporations that have a brick and mortar. But we've had complete remote workforces. We've had people who don't even have a headquarters. It's out of their a
Right. And
garage
I
or their
see other
house.
attorneys advising people to invest all this money to create an office before filing an H-1B, but it's not necessary. And we have so many hybrid and remote teams that are our startup clients. So we have that expertise. I think we talked about this already. So if you do a change of status, the earliest start date we can request is October 1st. If you travel, it will jeopardize it. And if you, so like this is something we want to talk about. We also mentioned consular processing. You don't have the H-1B kick into effect automatically in the United States. You would have to quote unquote activate it by getting a visa and entering the United States in H-1B status. Sometimes we've had people choose H-1Bs, but later they want to reactivate it through a change of status, which could be done. It's just not automatic. You have to like repay for the whole H-1B, but that's possible too. In terms of maintaining it and traveling, how long is an H-1B valid for? What do people have to do next?
So overall, when you file your H-1B, you have 6 years of validity, but it's broken into 3-year increments of, so you'll have an expiration date. For us right now, you'll be approved until 3 years from the LCA date. And if there's any changes, say you need to do an amendment on it, we can always request additional time to be added to it.
Yeah, and usually due to the timing of the lottery, the first H-1B is usually valid slightly less than 3 years, but you can always recapture that time up to 3 years or up to 6 years later.
Correct. And anytime you spend outside of the US, that's also time we can recapture. Or if there's any time that you go into another status, say that you have a valid H-1B right now, but your partner also has an H-1B and you're an ability to get an H-4 and an EAD through that. So you hop onto that status.
Yeah.
We can recapture that time and add it back.
Yeah, and just if you're our client, tell us before you plan to leave the United States so we can make sure you can re-enter. Get a visa if you need to.
Yeah, and also we keep a really good pulse on consulates, especially the major ones like in Chennai and Mumbai, getting a pulse of how processing is, especially during COVID. All over the globe, it was kind of up in the air, and as things are settling down right now, things are starting to open up. So we definitely try to keep a idea of who's processing what, if you're able to do third country processing. And
some of our clients are getting visas without going to an interview, which is nice.
Yes.
So that might benefit people this year. Yeah. And spouses can come, they can get H-4 status, but they can't work until you're at a certain stage in the green card process. So if your spouse needs to work, then they need to figure out an alternative option if you're new to H-1B.
Yep, and again, if you do want to have your dependents file for your H-1B petition, let us know. Or if you know that you'll be traveling shortly after your H-1B approval, we may just recommend wait until. Don't do it without. Y'all can go to the consulate, get the H-4 stamp, and re-enter that way. It's a lot faster because even though the beneficiary can premium process, dependents cannot. So the dependents cases can take months, very long time to get approved, and it's not necessarily the most advisable.
Yeah. We're getting a ton of questions. So I'll share about next steps, and then Carolyn will answer the questions.
Sure.
So if you want more of our webinars, the next one is on April 28th. That is the flip side of this coin. It's for people who were not selected in the H-1B lottery about all the other ways that you can live and work legally in the United States. The special guest, Danielle Goldman of Open Avenues Foundation, to talk about H-1Bs without the lottery. So if you're from a company and you have people in your team who you registered and did not get selected, and you want to learn about alternatives for how to keep them employed and on a path to a visa and a green card, please attend that. We'll be sharing that registration information with everybody from today's webinar, along with a recording of the webinar and some additional materials and instructions for next steps that we'll be talking about. If you are entering into the H-1B petitioning process and you need Alcorn's help, contact us. We're offering complimentary consultations for employers. We do not have the capacity to do individual legal advice consultations for beneficiaries right now. So if you need our help, please make sure that your employer is involved. And when you're thinking about this process, the government filing fees for USCIS and our legal fees, flat fees, we can discuss that on our call upfront, paid upfront, but all of that has to be paid by the employer. The employee is allowed to pay for premium processing if it's at the employee's request. But also, I think what people don't realize is that this actually does take work. We are not fortune tellers. We are not psychics. We do not know the information about your company. So our team is here to support you and manage the process. But this does involve some of your time, some of your energy, your commitment to provide us the information on time. You can't just think that you're going to hire us and things will magically happen. We need to get information from you to make it happen. So that's something to keep in mind going into the process as well.
Piggybacking off that, Sophia, I would say, just based off my experience, we also don't file cookie cutter petitions.
Yeah.
We don't do a single template for all employers. We definitely look at your company, look at where you are, what you're doing, who your employees are, and tailor it and make a petition that is very specific and detailed and covers and addresses your company's abilities and highlights that. There are companies who have, or law firms who have an approach where it's like, we file the same standard documents, we file the same type of letter, and they'll file 500 cases and they all look the same. That's not us. We do put in the extra work because that's one of the keys of our success and our high approval rates is doing that extra work.
Yeah. And ultimately it reduces RFEs on the back end.
Exactly.
So if you do need to contact us, and Alex will be putting this in the chat window for everybody, but we are offering complimentary meetings for company representatives right now. So please email us and mention that you attended this webinar. The steps are in the chat window. You can copy and paste them. Email hello@alcorn.law with your candidate names and emails. Have your candidate fill out our candidate questionnaire and make sure that anybody who got selected for an H-1B or anybody who needs immigration help at your company fills it out before you meet with our expert attorney. And then our team will provide a scheduling link to the company representative to get on a call with one of our attorneys and discuss options for all candidates. So now is the time to grab those steps from the chat window. And if you need our help in the future, you can always email us hello@alcorn.law or reach out to us through our website. We are on social media. Where you can hear about these webinars. You can subscribe to the Immigration Law for Tech Startups podcast in the Google podcast app, the Apple Podcasts, Spotify. We are on many platforms. We have a new episode on Tuesdays, and then you can also catch the columns in TechCrunch Plus every Wednesday. So we try to do a lot to level the playing field, to make this information accessible to people so that we can be here as expert counselors and advisors for you. So lots of questions. Kind reminder to please put them in the question and answer panel. So if you've put them in the chat window, please copy and paste them in the question and answer panel. If you would still like to have an opportunity for us to answer them, I will be going through that now for the next 15 minutes. All right, so somebody asks if we were approved for the H-1B through the lottery and we're pending to send the physical petition. Okay, so their registration was selected, but they have not yet filed a petition. Do they need to extend the OPT using the STEM extension? So I think you answered this, Carolyn. We would advise that they should, right?
Yeah, overall. And if it's a situation that you need support on the STEM extension, reach out to us. We do that, but it is something easy enough that you could do through your university.
Many students do it by themselves. Some people at early stage startups, especially people who want to be founders, often seek our representation for STEM OPT extensions. Here's another one. How probable is it for the H-1B petition to be denied after being selected in the lottery? I think it depends on the strength of the petition.
Yep. And if it's a situation where we are very upfront, if we do see red flags, or if we think that, hey, based on our experience, USCIS will likely issue us an RFE on this type of case, and this is what we'll need to support it on. If we do get that, we'll let you know.
Yeah.
Overall, though, we don't have a really high denial rate for our cases.
We have a very high approval rate.
Yeah.
And especially even within tech immigration. So like, if you have a funded company and the position is for an engineer and the person has a bachelor's degree in computer science or electrical engineering, even if it's an early stage company, chances are we can get it approved. And yeah, exactly as Carolyn said, like if there's anything else, we'll let you know, and you may still want to file, and we'll tell you what we're doing to make everything possible. Some of the weird edge cases are if you want an H-1B to be the CEO of your tech startup that you founded, that is a weird one that requires a lot of handholding, but we provide those and we can get that approved. But we have to make sure that you and your company are in compliance with all of the H-1B rules. So sometimes there's just some setup that we need to do to make sure that you're in compliance. Okay, next question. How can I get in contact with your team? Well, thank you so much. Please refer to the chat window. We would love to support you. This person mentioned they want to file their H-1B petition for 2 selected employees who do not have a work permit or student F1 status. They might have a visitor visa. What are the requirements? So we'll provide you lots of questionnaires, checklists, all the things we need. But this is a very interesting situation. I think the way I would phrase the question is, if somebody flies to the United States on a B1, B2 visitor visa with non-immigrant intent in early June, having been selected for the lottery, could they theoretically file for a change of status to H-1B to take effect October 1st?
Yes, technically they can. However, we would definitely caution a couple factors. We would want to make sure that their I-94 would stay valid throughout the time period for the filing. So if their I-94 is going to expire before 10/1, then we would recommend just do a consular processing, have them leave the US, re-enter once their H-1B is active. The other thing is, if they are staying here in the US the whole time, they do not have work authorization. And that's going to be very, very important to make sure that you guys are following that process and not having them do anything that could be considered work, because that could be a grounds for denial.
And let me tell them something that you cannot do. You can't have somebody come here for business meetings and promise them some big sign-on bonus on October 1st for the work they did over the summer. That would be completely illegal. The B1 is not for work, and any type of service in exchange for even the hope of future money can be considered work under immigration law. So don't do that.
Or even if you say that it's an internship, but it's something that technically you would normally pay for services for, that is a violation. So definitely be very cautious with stuff like that. But it is allowed and it is permissible, but it's something that we would want to walk through very carefully with you.
Okay. Here's another question. This is a bit of a change. This must be for a currently enrolled F1 student who has CPT, whose H-1B got selected. The maximum amount of CPT is like, the schools always want people to talk about CPT. I was recently meeting with like a dean of international students to understand CPT, and these were my notes from the breakfast. So it's very, very complicated, and schools usually don't want immigration lawyers messing around with CPT. There is a maximum. It's usually up to 12 months full-time, but I don't think there's a rule for part-time. But the point is, you could do a change of status from F1 to H-1B effective October 1st. Most schools will allow you to continue enrolling as long as you're maintaining the requirements of your degree program and your job. If you do the real H-1B job, then the school usually doesn't care if you're on F1 or H-1B. But this, I would say, is a conversation to have with the school, the employer, and the immigration lawyer.
And on the flip side, you are allowed to be in school while you're on H-1B status.
Yeah.
If it's a situation where you're not able to work the full 40 hours a week, part-time employment is also allowed on H-1B. So if you're going to do both, just let us know so we can file the petition as a part-time.
We can file the H-1B as a part-time. Exactly. Okay, here's a simple one. Let's say an H-1B petition through the lottery gets the approval notice through premium processing mailed out on July 15th. When will the H-1B change of status become effective?
Sorry, I did come by. I'm sorry, I did see that question.
Okay. Let me say it again. The actual question is, if an H-1B case is approved before 10/1,
okay.
does it mean the H-1B change of status will become effective before 10/1 as well?
Oh, no, it will become effective on 10/1. So the way we always described it, magically you go to sleep on the last day of September, and then on 10/1, you're in H-1B status if you did a change of status. You don't
and if you didn't leave the country, and if you didn't file a change of employer or some weird thing.
Yeah, and you don't need, a big misconception is that the visa stamp in your passport is the indication of your status here in the US. It is not. For change of status, it will be the actual I-797 approval notice that has your I-94 on it. But you do not need to have a current valid visa in your passport to be in valid status.
Cool.
So that is right on 10/1.
Thank you, Carolyn. Okay, Anonymous asks, I got selected in the H-1B lottery and am applying through a change of status and premium processing, anticipating that the H-1B result will come by the end of June. Can I travel to my home country, India, in August and return to the US with my H-1B stamping around the 1st of October? Probably, but talk to your immigration lawyer and make sure you have all the right documents. And if you can't get a visa in India in time, you might have to delay your return.
Yeah. In this situation, if you have the actual approval, you should be fine. But again, we would definitely recommend making sure that you get a consular appointment booked as soon as possible, or if you get your Dropbox appointment as soon as possible.
And it might be better to tell your lawyers to file as consular processing, since you're sure of your travel plans, and not mess around with attempting a change of status. Okay. How long can I be in H-1B status? Like 3 years or 6 years?
So technically it will be your full 6 years. You have full 6 years. However, they break up the validity period for 3-year periods. So if you have the 3 years, and then you have to file an extension and request those additional 3 years at that point. Yeah. If there's any changes in your employment or any changes in your, say you move locations, you change employers, you change jobs or roles, that would also require us to file an amendment, and we would request additional time at that point. But it's 3 years up to 6 years.
Cool, thank you. The next one let's take is, I have STEM OPT and was selected for the H-1B lottery. My spouse is on B2 tourist visa, and we're filing for him to switch to H-2B from B2. Will there be any issue for the B2 to H-1B process for him? You got to talk to your H-2B attorney about this for your
H-2Bs
unless they mean H-4 spouse. I'm not sure actually what this is referring to.
So if it is an H-2B situation where
that's
they're
temporary
going into
worker, right?
Yeah, those are tricky visas, and they have a very specific requirement on you have to leave after your period of stay, or you can be in violation of the visa intent on that. So if it is an H-2B, talk to the attorney who's handling that case and let them know that you are planning on changing that. But if it's saying like changing to H4 and all that, we would be able to assist in that option. I think we skipped one.
Do you know the answer to that one? Hold on. We'll take that one next. How about that, if you know the answer? For this one, I have a dependent in F2 status. If my status changes to H-1B, should my dependent apply to H-4 too? Yeah, you should talk to your immigration lawyer about that.
Yes, because if you change out of your F1 status, you would need to file an H-4 for your dependent, because their status is tied to you. So either you would want to file if you're doing a change of status, you would want to file a change of status for your dependent, or if you're doing a consular notify, once you get your approval, they can go to the consulate, get their H-4 dependent visa and enter in on the status.
Cool. Okay, I don't know the answer to this next question. If you do, please go ahead. And if you don't, that's fine. And we would just offer a paid consultation to the employer in this situation for us to research it. Somebody is on a part-time H-1B visa for 30 hours a week. And the question is, can you take unpaid leave and how to maintain your status during the leave?
So the question on that, and this would deal more on the employer side, because you would want to try to avoid a situation where you get what's called benching, where you put someone on unpaid leave for a period of time. You would still be responsible for the pay for the individual under the LCA during that time. You could get hit with back pay and back wages for situations like that if it's an extended period. If it's a short time, say that the individual just is going on a vacation, they don't have any PTO left, and they're going to take the unpaid leave, that's fine. That's not going to be an issue. But if it's a situation where you are, as a company, know that like you're having funding issues, you're asked them to take the unpaid leave, they can come back and ask for that pay in the future at a different time.
If the H-1B folks left the country, if they can't be
correct.
Paid. But if it's like a parental leave or pregnancy thing, like that's fine, right?
Yep.
Okay, great. Who can file a change of status? Somebody who's in valid status, maintaining their status in the United States on October 1st, or September 30th. So correct. If you're employed somehow, you need pay stubs showing you were paid correctly. If you're not authorized to work, then you couldn't have been working. You have to be actively in valid status in the United States on September 30th. Oh, this one. How soon can I change my employer after an H-1B approval? Can I switch jobs before the October 1st deadline? This is where it matters if you're seeking a change of status or consular processing. Do you want to take I don't know if there's a quick answer to this, but can you try to answer this quickly?
So it's going to depend. If you're doing change of status and you 10-1, you change to your H-1B, technically the new employer can file a petition for you at that point. And what you would want to do is try to make sure that you have if you are changing employers, we always advise that you wait until you get the actual approval on your transfer before changing your leaving your current employer, because that way you are protecting your underlying status, because the employer will likely withdraw your H-1B petition. Mm-hmm. If you're doing consular processing, then you're going to have to wait until you come into the US, activate it, and then the employer will do a change of status at that point.
Cool. Okay. Well, that is all the time we have, everybody. Thank you so much for attending, for your very detailed questions. We would love to support companies with getting these H-1Bs filed, so please reach out to us as soon as possible if you're looking for that assistance. Thank you so much, everybody. Thank you, Carolyn. Thank you, Alex.
Thank you.
All right. Have a wonderful rest of your day, everybody.